So they spoil you. Good morning.
Oh, sorry.
I'm good. How are you? Good. I'm here. Good start.
Are we waiting on that one, Galen?
I have no idea.
Well, as long as we're all here, and I believe that's all that's going to be here, are you still desirous of proceeding with your motion?
Yes, sir.
All right. Then you are the movement, so you have the burden. Come forward.
All right.
Are we starting now?
Yeah, oh, I'm sorry.
We don't have microphones, so everyone will need to speak up.
Okay, ready, Sue? All right, I'm sorry, Sue, give me a heads up. All right, that being said, we are going to call the pre-trial to order, and the first order of business, there's a pending motion before the board here today, actually before me, it's a matter of law, and that therefore I will let you proceed with your motion.
Thank you very much. So I think at the outset here, given the kind of back and forth nature and complicated timeline, just a summary of the timeline of events leading up to this motion is pertinent, and I will go through it fairly quickly. So on 12/7/2022, both Mr. Harris and I received the amended scheduling order with dates. That date said that Mr. Harris's witness and exhibit list would be 1/24/2023. That gave him a 48-day notice to prepare his witness and exhibit list. Again, a 48-day notice to complete it and get it filed and get it sent over to us. One day before that deadline, 1/23/2023, Mr. Harris sent the witness exhibit list to Nico, not to us. And at that time, he actually had one more day. He filed it early, which is very pertinent later on when it comes to, he actually had more time to complete it and double check it and make sure it was up to his standard, and that included everything he wanted it to. After then, he submitted that with witness and exhibit list. On 1/31/2023, he attempted to submit a new video via email. Again, on 1/31/2023, when he attempted to submit this new evidence, that was 7 days past the deadline he had to file that. On that same day, we moved to dismiss based on the witness and exhibit list deficiencies, namely Mr. Harris being unable to prove his case based on what his witness and exhibit list says. On that day, Mr. Hearing Examiner, you confirmed that this would be resolved by a briefing. Set a briefing schedule and provided both parties those dates. Those dates were 2/7/2023 as a briefing deadline for us and a 2/14 date for Mr. Harris. On that same day, Nico confirmed that schedule and then sent everyone a calendar invite to remind us of those dates. Again, that was at least 3 notifications that the response to the motion was due 2/14 for Mr. Harris. Continuing on, the very next day, 2/1/2023, Mr. Harris again tried to submit new evidence not named on his witness and exhibit list, namely a Greyhound bus video. That was 8 days past his deadline to submit, and at that time we noted our timeliness objection, and we got no response on whether or not this would be allowed exclusively by the FCC. Of note is we still don't have access to these videos via Mr. Harris, so we don't know actually what the evidence he was attempting to submit is. We were given a flash drive of evidence from the FPC on 2/7/2023, but we're unsure if that's actually the evidence Mr. Harris tried to submit, as we still have not been given access to verify what those late submissions were. On 2/7/2023, Mr. Harris and the FPC received our truncated witness and exhibit list and our motion to dismiss with prejudice. Again, we should have alerted him that he had to respond to this and reminded him of those deadlines. A week passes, and on 2/14/2023, at 7:27 p.m., Mr. Hearing Examiner, you confirmed to us that you had not received any reply from Mr. Harris. At 9:02 p.m., Nico then confirmed that Mr. Harris missed the 4:45 p.m. deadline and defers to the hearing examiner and the executive director as to whether or not a late response would be allowed. We had not heard whether or not a response would be allowed, and we still haven't heard. At 10:38 p.m., in response to these emails confirming that he missed the deadline, Mr. Harris files his quote-unquote reply. Of note, in that reply, it doesn't address any of my motions arguments. It was totally non-responsive to the actual issues at hand here, and in fact, was barely more than just name-calling and throwing baseless insults. And those insults namely at Brendan, when in fact it's my motion. On 2/15/2023, Mr. Hearing Examiner, you confirmed that the motion will be considered according to law, regardless whether or not Mr. Harris had counsel available to him. And then 2/21/2023, as I'm sure you all remember, we attempted to have a telephone hearing on this matter. At that time, Mr. Harris claimed that he had not received our motion, which is demonstrably false for a simple reason. He made reference in his late, untimely, quote-unquote, reply to the fact that we looked up social media videos that he posted himself. That link to that evidence
Objection.
from our witness and exhibit.
Wait.
Okay, I'm sorry. I apologize.
No, that's okay. I mean, what's the objection?
To the videos of my social media that they got, that they're trying to use to detain my value of a person. And I would never put my social media videos or my childhood background on a case like this. So they did that per investigation, which means.
They have a right to investigate this.
But at the same time, sir, that my background, my childhood background, being that I'm 40 years old and a single daddy with 3 kids, doesn't hold up to these case standards. So that objection, I was going to object more, but I was going to try to let him speak. So I
understand, but understand that anything supplied.
No, it's illegal.
Stop, please. I'll determine what's illegal, okay? That's my job.
I know the law too, so.
Okay, well, that's good. But understand that it all requires a consideration of any sufficiency of the evidence and its relationship to being relative to, responsive to whatever we have. So.
But this is based on I'm sorry, sir. This is based on the officers' negligence to where they was.
Yeah, well, now you're getting into the merits of their conduct. Okay?
But that's what he's doing, sir. So if you're going to allow him to speak out certain things, then I need to speak too. But I was trying to wait.
You haven't turned.
I'm gonna wait. We can go. Let him finish.
All right. Continue.
As I was saying, on 2/21/2023, we had this hearing via telephone, and Mr. Harris said he did not get our motion. That, again, is demonstrably false because he made reference in his response on 2/14/2023 to the social media post in our evidence. That evidence was linked in the same email that we sent the motion over and our witness and exhibit list. He could not have known about that evidence being provided unless he got the email with our motion. So any claim that he didn't get it is just patently false. And if you recall, at that hearing, we actually all confirmed that he did receive that email, and we saw that all of those attachments were on that email as well. So turning to the actual motion now, it's pretty clear to almost everyone that his witness and exhibit list cannot prove the actual merits of the case. On his witness and exhibit list, he named 4 witnesses, and I'll sum up my motion very quickly. First, he named a Jacob Bachek, spelled incorrectly. It's unclear who a Jacob Bachek is, and it is clear, however, that Mr. Harris knew who the proper officer was. We have video proof that he had the charges and specifications from the FBC, read through them, and actually in his caption he spelled MPD police officer Jacob Bachek correctly. So any reference to a JCAB in his actual witness exhibit list is clearly intentional, and it's unsure who that is and what evidence they can provide. Second, he named a Michael Mahalik, who it's unclear who that is or their involvement in the case. The actual officer was a Richard Mahalik. And again, for the same reasons with the JCAB, it's clear he knew that Richard Mahalik was the actual involved officer.
Objection.
Cases, one word.
Based on his terminology of I didn't know who these people was, followed by these people are Milwaukee PD, And the complainant that he is trying to say that I didn't know, he's the actually complainer. And also, if we talking about names, how we been spelling names, then you can also, I have proof of reports that was misspelled my name and different reports, the police report, the state's attorney reports, and also this case is an ongoing case, preside this case. So I'm still going against these officers trying to prove my innocence because they trying to take my CCWs away, which had nothing to do with what happened at the scene. So once again, this have nothing, well, his argument is irrelevant because none of that, I have no idea of what he's talking about. And being that I'm representing myself, he feel to take the advantage and using his whatever he using to try to get this case dismissed. These officers are wrong. They don't need to be on no force. I'm for officers, but these officers don't need to be on the force. And the only proof he got, I got my proof. Now, if he don't want to look at the video, you keep saying it's not my turn on the objection, but this guy is allowed to keep saying all these stuff about me. I'm gonna object to that, but okay.
Well, you can object, but it's my job to rule on whether or not it's your turn. Right now, they're doing theirs.
Can I have a question for you, sir?
No, you can't, because I can't give you legal advice.
I'm not giving no illegal advice. This is not about illegal advice. This is about, is this supposed to be a hearing on me or the negligence of the officers? Because if he's saying that I knew about all this stuff, which I have someone, I don't do paperwork, right? Because I have a reading disability, but I do know the law. So, with that being said, the people that helped me do this paperwork didn't have no knowledge of what this, and when I was only told to bring the video that they wasn't able to see. So once I brought that in personally, that's when these emotions came about to dismiss the case. So being that it is evidence, that's when these emotions come. Otherwise, it wouldn't be no emotion.
Well, the motion is their position. You have yours.
So what's my position?
I'm not, you're going to go next.
Okay, then I'll wait till my turn.
All right.
But I'm going to keep objecting.
Go ahead, sir.
Thank you. So again, Michael Mahalik is improperly named, unclear who it is, and cannot provide any relevant testimony. First, even if we give Mr. Harris a leeway and say he meant to say Jacob Bachek and Michael Mahalik, those two witnesses will not provide any testimony about the case. Their testimony will prove that their actions were
Objection, we don't know that, sir.
Please.
I'm allowed to object.
Well, it is, but you have to have a basis.
I do have basis. Because
One word basis, that's all.
okay, you're not giving him that.
He's not objecting.
But I have a right to object because this is on me.
One word basis.
Okay, one word basis, he don't know. He can't give out claims to what other people are capable of doing. So that's my word, one word or two words, objection. Well, okay, I want to see you overrule some of his stuff then.
No, you don't see anything, please.
Sir,
Please, you've got to understand. I don't want to argue with you. I'm going to make rulings. You may not like them, but here's the deal.
I know there are bonds that are being set in place as a Moors America. There are bonds that are being set in place. If I'm not treated accordingly to this case, I will go out to people bonds. So if you're going to hear him out, you're going to hear me out. I'm going to wait till my turn respectfully.
Please, I've asked you nicely. So
Okay, let's continue.
please.
Let's continue, please.
Please, with your motion.
Thank you, Mr. Hooninghammer. So as I was saying, Officers Bachek and Mahalik, my clients, their testimony will not serve to prove Mr. Harris's case. Their testimony will only show that their conduct was lawful and will serve to prove.
Objection. They was charged for what they done.
Well, it's before this commission. There's no determination as to whether their conduct was appropriate or not until
It's on paperwork.
the commission rules.
It's on paperwork.
Proceed.
Thank you. So again, for the third time, their testimony will only serve to show that their actions were lawful.
Objection again, on the same basis.
Noted. I know what your objection to, their actions being lawful. Go ahead.
Thank you. Turning to the third witness, a Brian M., it's unclear who that witness is. There's no one in the case named Brian M., and if Mr. Harris intended a Brian M. to be someone else, that witness should not be allowed to testify. That would be clearly unfair.
Objection. That was the complaining witness. That was the complainant of the call.
But his name's not Brian M.
Well, my name is not spelled the way it is on the paper, but they got it spelled wrong. I can prove that to you too right now.
Well, if you have a term.
Okay,
Again,
I'm just suggesting.
But I'm just saying, Brian M. There is a Brian McMillan that's listed in the file, but not a Brian M. But I'll consider its relevancy and its weight to be given. Go ahead.
Thank you. As I was saying, if Mr. Harris intended a Brian M. to be this Brian McMillan, it's unfairly prejudicial to allow this witness to testify against the officers. The point of a witness in exhibit
Objection.
is to put the...
He's using prejudicial, and them are two white men.
Well, overruled. It's not.
Presidential. That's like me saying that this case right here is racist because I'm here defending myself, and based on me being a black man, I don't have rights. So yes, it is presidential because there are two white people that's coming against me, or whatever the case it is. That's his statement. Presidential. We got to know how to use words, and since he want to say words and he educated to use these words properly, we want to use these words because when you say racist, that means I'm racist, he racist, everybody racist against some part of the person. These are two white men that he are talking about.
Well, but again, that has no relevancy.
It's relevant to the case because he used the word racist.
I'm going to overrule, but let's not use the inflammatory words either way. Okay, let's go.
I would like to note I didn't use the word racist.
You did racism. That's what you just said, sir.
All right, let's proceed. Please, let's get on with the basis. I can be bringing that.
Thank you, Mr. Hearing Examiner. Again, this Brian M., it's unclear who he is, what testimony he could provide, and if it is this Brian McMillan as well, to our knowledge, that witness did not actually see the events that occurred between the officers. and
Objection. He was there, so you can't elaborate. That's hearsay on your behalf. He the one made the call.
Well, I haven't heard the testimony, so that's what I'm talking about. Credibility and sufficiency of the evidence is at the crux of this case.
Okay, that's credibility based on him making a phone call and sending them off to
That's
lawful
your report to
detain me.
police as opposed to witnessing what you're saying.
So what we here for? If we here for y'all to just to throw the case out and see me because I'm sitting here trying to defend myself and he coming up with all these records about this stuff because he have power or whatever, and you got two people against one person, one black man, up in this room, and y'all trying to treat me like I don't know my laws, like citizens can't know the law. The law is that the constitutional of these officers was broken by the officers, and their oath was broken because they didn't uphold their oath. That's what this guy is trying to basically get these, what's your name? He's trying to get the videos out because the video is the only proof that shows their negatives. That's this whole argument. He's sitting up here saying names, these people. I have the same paperwork he got with my name and different reports of my of what they trying to say against me. So I'm not here to disrespect you or this courtroom, but why I'm here is for respect. Because if this is based on the officers disciplinary, and then it needs to be based on their disciplinaries and not what I wrote, because I didn't write none of this. I have help with this.
All right, wait a minute now. Because you chose not to have an attorney.
Okay, I'm not as rich as your officers, and I'm not rich as it doesn't matter. As a citizen, I have a right to defend myself. I do have rights in this land, and I'm Moorish America. This is my land, and I'm not gonna let y'all bully me here. So if y'all gonna take this case and dismiss it based on the fact that he got this stuff going on, then that's dismiss this case because it's been going on too long. And I have a right. These officers out here doing bad. I'm for officers. I'm for good officers. But as a Moorish America, y'all not finna bully me.
Please, I've asked you nicely about 100 times.
And I only object.
Well, object, but you have to have a proper basis.
It is a proper basis. You're not seeing my proper basis. I even haven't got a chance to set yet.
I don't agree with you on your basis.
Well, you're not going to agree with me. I'm a black man.
I'm gonna say this one time.
You said it twice.
No, I'm gonna say this one time.
Because you moving to the most and dismiss, and you using me not having an attorney to do it.
It's nothing to do with you not having an attorney.
So if this case don't get heard right, I will be coming at people bonds.
You simply aren't following the rules that we have to follow.
Sir, I'm not in this courtroom to know rules and regulations. I'm only in this courtroom to document myself as a legalized citizen of this land. That's only rules I know. I didn't sign no application with you guys or no contract with you guys to follow any rules, but to speak on my behalf. I'm here on my behalf. The point is on my behalf.
It's not your turn.
Okay, then let him speak. Then tell him to move along.
It's not your turn, and if you interrupt again, I'm telling you right now, I'm gonna have no choice, but to act, in my authority. Now, I don't wanna do that, I wanna have this stuff be aired, but I gotta make a record that's appropriate. And you're screwing up this record, I'll tell you that in King's English. And I'm not gonna let you do that. And if you try to do that, it's not gonna happen. So I'm making it very clear. So please. All right, continue.
Thank you, Mr. Hearing Examiner. Turning now to the fourth named witness, Diana Perez. She is properly named, but she cannot actually be used to prove the actual events of that day. She can only provide hearsay testimony, which of course cannot be used to prove the basis of the allegations. She can only testify and prove the truthfulness of what she was told, not the actual truthfulness of the events. It is worth noting that the FPC rules do explicitly allow hearsay evidence to be heard and admitted, but the rules do not provide that they can be used to prove the basis of the allegations asserted. So again, the FPC rules allows hearsay evidence in, but it cannot be used to prove the truthfulness of the events. So Diana
Objection.
Basis.
I'm a just object because you don't want me to speak.
One word.
Because one word, I can't use one word, sir.
All right, overruled. Go ahead.
Thank you. So Ms. Diana Perez cannot be used to prove the truthfulness of
Objection.
that day.
Basis.
Based on he can't determine what can be said or used in a proceeding that doesn't require his knowledge of where being. There's a reason why I'm using these witnesses, because she was one of the ones that did the interview. So in an interview, we're not going to get into that. That'll be my situation.
Basis. There's no basis.
It is basis. You're not going to see it that way.
Overruled.
Objection.
Thank you. It's also worth noting that Diana Perez, her investigation came to a different conclusion than the FPC. She actually found that the officers did nothing wrong and that they shouldn't have been charged. So again, Ms. Perez's testimony will just serve to prove that the officers acted lawfully. Notably, is Mr. Harris didn't name himself.
Objection. That is the sergeant, so she wouldn't.
I'm sorry, so she wasn't there?
The lady who he's talking about is the sergeant of them.
Perez?
Not the lady who did the interview. Not the one who did the interview for them. The sergeant who did the interview with Perez, or the lady whoever did the interview who charged them with it, is. I have basis of using them as witnesses. I have proof.
All right, but we don't have this.
Well, I have proof in my file. So that's the reason she's on there as a witness. I mean, he's not going to come in here and give me every witness he got. He's not going to come in here and tell me every argument he's using his witness for.
Well, then you may not be allowed
So
to use those witnesses before the hearing.
Okay.
That's all I'm saying to you. I mean, it does go both ways.
Well, if I'm okay.
I just want you to understand, we go both ways.
I hope so.
Well,
Cause I'm a single dad.
I don't care.
Well, what you mean you don't care?
If you have 88 kids, or you got 10 wives, that's a difference to you.
See, that's where you out of line at, sir. I'm object to your comment, because you can't say you don't